in some judgments, some landmark judgments, this retroactive effect has been discussed, and that has also been referred in this judgment. You can go through the judgment. And one thing that this is one important thing that I wanted to highlight. So there are three types of operations. One is retrospective, second one is prospective, the third one is retroactive. Yes. So we are here just to discuss about the decision, and just I will put forth my opinion. So the judgment, Vineeta Sharma judgment, settled at rest the confusion created due to conflict in judgment. Whether these guidelines, these 5 points which the court has given in Vineeta Sharma, and they are very express. That means there is no confusion. It is very clear, and about all the issues that have been coming up before the court since 2005 and differently interpreted by the High Court. So it has settled at rest the confusion. So everything is clear. And now it also balanced the interests of the daughters as well as the male co-partners. So the first 4 points, it safeguarded the interest of the daughters, and the fifth point, it safeguarded the interest of the co-partners. So in this way, we can say that it is not tilted in favor of the daughters 100%. Even it has taken care of those co-partners where the male members, and they have made those genuine partitions which are orally made, but which can be proved with documents. Okay, those partitions are also safe. They are outside the scope of the daughters. Now, it has widened the legal platform to accommodate more and more daughters into the beneficial net, and all the daughters born at any point of time, whether father is alive or not, got the benefit. At the same time, brought within 6(5) oral partitions with strict documentary evidence and saved them from daughters' claim. So this is, we can say that it is a balanced judgment. The things that we have to ponder, already I have suggested this. Intention of the legislature has not been derived regarding section 6(5) and the term partition. When I take you back to the that is the recommendations of the standing committee report. Okay, it is proposed to accept this recommendation and make suitable changes in the bill, but it is also there in the paragraph 107 in the judgment. But the legislature has deliberately omitted oral partition and family settlement. Family settlement is also one type of, that is a partition that takes place mostly among the Hindu families. Okay, so in 6(5). So to that extent, the intention of the legislature has not been properly appreciated. The second one is, there is a departure in the same section 6(5). It also pertains to this section 6(5). No word can be added or read into the statute by the court, and court cannot fill the legislative omission, and it is for the legislature to provide for it. So here, this opens up a new window for further interpretation. So whether the judiciary can include something which has not been intended by the legislature, and whether any legislative omission, causa omissa, and that is one point, that is one term that we use in the interpretation of statutes, that if the legislature has omitted anything, or if the courts feels that there is a omission in the legislation, can it fill the gap? Whether the court has got, it can fill the gap in the legislation. So that is also to be pondered. So it opens up a new window for further interpretations. And we can also say that this judgment, we cannot presume that this judgment is going to be final judgment. And there may be some more judgments of the Supreme Court. And but this is that is my personal opinion. Though it is settled many points, okay. And this one, 6(5), it may open up certain controversies. Next, it is not with regard to any legal point. In para 50, the judge, that is the court, it has highlighted one Irish court, which has been used by the court in one Savita case. and it pressed into service that quote that son is a son until he gets his wife, but daughter remains always as a loving daughter. So here, this such statements, okay, when we hear such statement from the court, and it is uncomfortable. Okay, so there is a distinction, that is, even the court feels that for the son, till marriage he will be a son for the parents, but after the marriage he will not be a son, or these ideas or these expressions, and they can be avoided, and it exhibits a biased view, and it also gives scope for controversies, slipping into controversies. So here, these are the opinions and the ideas, or I gather from the judgment, and I put before you in this presentation. And now I am ready for any questions to be taken up. Okay.
Yes, ma'am. There was a very basic question I have. So you use this word unobstructed heritage and obstructed heritage.
Okay.
So can you just elaborate on these terms?
Yeah. So how can I am not visible, na?
No, you are visible.
Yeah. No. Yes. So here, can you please repeat it? Sorry.
So you have used these words while presenting the So there was this word unobstructed heritage.
Okay.
So what is it?
In Mitakshara family, there are two types of heritages are there with regard to co-pastoral property. Actually, okay, that is, there are two types of properties. One is separate property, and another one is ancestral property. So the co-partners, they get a right by birth only in the co-partner property. And what about the right in the separate property of the father? In the separate property of the father, during the lifetime of the father, they cannot ask for any share. So if the father has not left any will, because father is the absolute owner of his separate property, and he can also execute a will. Suppose he has not executed a will, but that means testamentary disposition has not taken place, then intestate succession will come into picture. That means after the death of the father, the separate property of the father, that will be inherited by the sons as well as the daughters, and even mother and the widow and the branches of the predeceased daughters. Okay. So here, any heritage which a co-partner cannot acquire during the lifetime of the owner of the property, that is called obstructed heritage. The lifetime of the owner is an obstruction for him to inherit the property. But on the other hand, the co-partner property, that means ancestral property in the hands of the father. So I have already told you that the son is a co-partner along with the father. The son's son is also a co-partner along with the father. So here, the son or son's son need not wait for the death of the grandfather or father. And because they acquired a right by birth, at any time they can claim. If they claim, the father or grandfather cannot object or cannot deny their share. So that is called, that heritage is called without any obstruction. That is called unobstructed. So that is called, in co-partner property, the co-partners will have, the sons will have unobstructed heritage, and in the separate property, the sons will have obstructed heritage. So these are the 2 points. Apratibandha daya, that is called unobstructed heritage. Sapratibandha daya, that is called obstructed heritage. Okay.
Thank you. And my second question will be in 2 parts. So do you believe after this judgment, there would be a surge in litigation by daughters for claiming their rights in the property? On the second leg is, now instead of pressurizing for dowry, the groom's family would pressurize the bride to file for litigation and claim a property.
So this situation has come into force even from 99-2000. There is no new situation. Yeah, and there won't be any new situation as compelling the daughter instead of dowry, that is compelling the daughter to get a share. And even in 2005, that right has been accrued to the daughter. In some families, the husbands may pressurize the daughter. So here, one is entitlement. Suppose if the daughter is given her share, there won't be any pressure from the husband. So it is only a social practice. And the male co-partners, the brothers and the father, they will not give the property to the daughter. And on the other hand, daughter will be pressurized by the husband. Here also she can neither quarrel with her parents or quarrel with her that is brothers, nor she can satisfy the husband. So this is the problem. This is the situation. It is a social situation, we can say. But legally, she is entitled for her property. So if the property is given to her as per the law, then there is no pressure from the husband.
Yes, ma'am. Yes, ma'am. Thank you, ma'am. And there's this question. Since the court has used the word retroactive instead of retrospective and prospective, and you have already discussed that, but still I would like you to speak something on this exact word. What does it refer to?
So retroactive. So here in this case, in 2000, that is in this 2005 amendment, and the daughters, when they can, from which date they can exercise the right? They can exercise the right only from 9/9/2005. They cannot exercise the right before 9/9/2005. The right to exercise, that is the right to exercise her right, has given to her, has been conferred on her only from 9/9/2005. That means enforcement, how she can enforce her right, that is only from 9/9/2005. But that is why she has been given that right, because she has been by birth become a co-partner. When did she become a co-partner? Not after 9/9/2005 necessarily, but even prior to 9/9/2005. So that status has been accrued to her by birth. The birth date is always antecedent. That is, it is a retrospective date. It is a back date. So reference to the back date is there. The status has been conferred to her from the date of her birth, but the right to enforce her right is conferred to her post 9/9/2005. So that is why we can say that it is not fully retrospective in operation. It is not fully prospective in operation. It is a mixture. So the word that has been used is retroactive.
Thank you, ma'am.
Oh.
So I have other questions, but you have already covered them somewhere or other. So it would be stupid to again go into the same thing. So thank you, ma'am, for accepting our invitation. Thank you for explaining, and we would look forward for another webinar from you.
Okay, thank you so much, Ma. I congratulate you, the organizing team, for such a wonderful activity, academic endeavors and activities that you are doing. And then I also thank all the participants who have patiently heard this, participated in the discussion, even though they are muted. And this is the system that in online, the participants are muted. Only the moderator and the speaker, their faces are visible and their voices are visible. But this is the limitation that we get in the online platform. But in further activities, you can also think about the participant unmuting themselves. Okay, one by one. Okay. And they can also participate. Okay, that means they will have some interest, some kind of interest, that their queries are addressed, that their voices are added, or their faces are made visible. Okay, this you can do, because in many webinars, in many webinars nowadays, every day we are getting some webinar. In some webinars, this system is being followed. So if it is practical for you, okay, you can also think about it. So I thank the participants for patient hearing, and I congratulate the organizers, and I also thank the organizers, the team, the peer support network, isn't it? So yeah,
Yes, ma'am.
and please keep on doing this such activities, and I will extend my cooperation from my side whenever it is called for. Okay, you can take an assurance. All the best. All the
Thank
best
you,
for
ma'am.
everybody. Okay, good children. Okay.